Lesson number 2. Why is this case important? The government asks that question all the time whenever we're in court, because according to the government at least, the warrantless wiretap program was ended in early 2007. And if we have time for questions, I could explain why the case isn't moot and while we're still standing there. But why is this case really important? The case does involve issues of how to deal with classified documents and state secrets privilege, and I'm going to talk about that in a minute. But most fundamentally, this case is about what limits there are on the assertion of inherent presidential authority by the executive in the context of national security. Now, that issue was addressed in the Guantanamo cases, such as Boumediene, but only in the context of habeas. Those cases are fairly restricted to habeas corpus cases. But there have been no cases yet where a court has said that what the Bush-Cheney administration did was unconstitutional. There are principles here. The principles arise primarily out of what are known as steel seizure cases, which are back from the early 50s when Truman tried to nationalize the steel industry. And some principles arose in those cases, but there have been very few cases discussing those principles since that time. This case poses that issue. There are many other cases, by the way, that have talked about the legal context and the political context of this case. And you should read the case the book by the New York Times reporter Eric Lichtblau, wrote a book called Bush's War. There's a great book by Jane Mayer, a New Yorker reporter, called The Dark Side. And there's also a book by James Bamford about the NSA surveillance program. But in terms of the legal principle, this is a case we hope that will ultimately establish the principle that what the Bush-Cheney administration tried to do was illegal and unconstitutional, and that no other executive should be doing this in the future. That's number 2. Number 3, I want to finally talk about the issue of the classified document and how that's been handled by the courts, because if you do these cases, that will become an issue in the case. From day one in this case, the government took the position that we could not use this document that we had, and we needed it initially, we thought, to establish standing in the case, that we could not use it based on something called the state secrets privilege. So 3.5 years ago, we all said, what? What is the state secrets privilege? The privilege has been around since a 1953 US Supreme Court decision called US versus Reynolds. And it's been rarely used at that time until the Bush administration, which began to assert the state secrets privilege over and over again, and the Obama administration has learned how to do it quite well also. Now, it's not unusual that classified documents are used in cases. For example, if any of you do criminal cases, there's in fact a separate law. It's called SEPA, which sets forth procedures for using classified documents in criminal cases. Classified documents are being used in the Guantanamo cases right now. But by asserting the state secrets privilege in our case, the government was saying 2 things. Number 1, and this is what the privilege says, the case must be dismissed because the very subject matter of the case is a threat to national security. The government's position, and they have said this in court to the judge, is that if you decide that these people were surveyed without a warrant, that will be a threat to national security. That will signal all sorts of information to our enemies out there. On the other hand, if you decide that there was a warrant in this case, that will also be a threat to national security, and that will signal all sorts of information to our enemies out there. So therefore, Judge, you cannot decide this case. The very subject matter of this case is a threat to national security. Now, the second part of the state secrets privilege is that even if the subject matter is not a threat, the use of the document is a threat. And if the court agrees that the state secret privilege applies, then the document cannot be used in the litigation at all. There's no balancing of interests. There's no use of protective orders. The document is out. So for the first years of the case, and the case was initially filed in Oregon federal court, it was moved through something called the panel on multi-district litigation to the Northern District of California, and that's where the case is at this point. But after the Oregon decision, and the judge basically tried to find a way to get around the state secrets privilege, the government appealed that to the Ninth Circuit. The Ninth Circuit held that indeed we've looked at the document, it is a threat to national security, and therefore the state secret privilege keeps you from using this document. We were somewhat surprised by that ruling since we had seen the document, and at least we couldn't see what was going on. But we also didn't see the classified filings that the government made to the Ninth Circuit explaining why this document was so serious. So when we wrote our brief to the Ninth Circuit, we could talk about the document as long as we went to this secure room in the federal building in San Francisco and wrote our arguments on the brief on a computer given to us by the government, and which then printed out copies of the argument, gave it to the 3 judges, but we weren't allowed to keep copies of what we had written. So that, again, read the New Yorker article, and I'll talk all about that. But we didn't know what the government was saying, so we really weren't able to argue much to the Ninth Circuit. Nonetheless, they decided we couldn't use the document. But we had not a bad panel in the Ninth Circuit, and there was a significant but in their decision. Because FISA, which we had sued under, the Foreign Intelligence Surveillance Act, has a separate provision regarding the use of classified evidence in litigation. No one had ever litigated or talked about, there are no cases about that provision. But the Ninth Circuit said, and we had argued this, it is possible that that provision preempts the state secrets privilege. And if it does, even though you can't use a document based on the state secrets privilege, you can use it, maybe, based on this provision in FISA. So we're going to send it back to the district court to resolve that issue. So we breathed a sigh of relief, and we went back to the district court. And the district court then issued a decision agreeing that the provision in FISA preempted the state secrets privilege. Great decision. But there was a significant but in that decision as well. Because the court said, but before you can use that provision, you have to make a preliminary showing that you are covered by FISA. In other words, that you were subject to electronic surveillance. And you have to make that preliminary showing without using classified evidence. So, I mean, this is driving us crazy. We had the document, I'd seen the document, I knew what the document said, I knew the document would allow us to establish our case, but we, at this point, still couldn't use the document. But in the years since we filed the case, there had been more and more admissions and testimony by the administration about the warrantless wiretap program, primarily through congressional testimony. At the time, FISA was amended in the summer of 2008. In fact, the assistant director of the FBI had given a speech to a national banking association, and remember, finances and controlling finances was a big issue here, in which he said and acknowledged something which the government attorneys had refused to acknowledge, that yes, we had surveyed Al-Haramain Islamic Foundation, and Eisenberg found this on the FBI's website. So we put together a very, very detailed amended complaint which spelled out each step of our analysis of why we felt we could prove, at least make a prima facie showing, that we had been subject to electronic surveillance under FISA. And the judge, Judge Vaughn Walker, who's the chief judge of the Northern District in California, in fact said, you're right, you did it. And he actually began the hearing by coming out, and when the government attorney stood up, said, made a statement about, well, Mr. Capolino, who's a Department of Justice attorney, There sure seems to be meat on them bones at this point.